Hello everyone, it's Mark. Welcome back to our video Q&A series. In this video, I want to talk to you about the hearing on a petition for involuntary placement filed by the state's Baker Act facility and when that hearing is going to take place. So the facility has the right to hold you for up to 72 hours. That's the stabilization period they have. And obviously if you're stable within 1 hour, 2 hours, 10 hours, or 24 hours, they're supposed to let you go. However, that rarely, if ever, happens, unless, of course, you hire a private lawyer like us, and then, that it does happen, and it happens frequently. But if the facility is planning to keep you beyond 72 hours, and I've talked about the criteria you can look for to determine if they're actually going to do that, such as does your loved one have health insurance, that's a very strong indicator that they're going to keep you and make sure that your loved one stays there. But if the facility wants to keep you or your loved one beyond 72 hours, they're going to file a petition for involuntary placement. So at that point, the court is going to set a hearing. Well, when does that hearing take place? Well, the statute says, and I'm going to read you the section of statute that's applicable, the court shall hold the hearing on involuntary inpatient placement within 5 court working days unless a continuance is granted. Well, working days does not include the weekend. So they get 5 days potentially plus the weekend, and they can move for a continuance. Perhaps their doctor or doctors that did prepared the petition aren't available. Well, they're entitled to prove their case, and so they ask the court for a continuance. So in theory, you could be held for 5 days plus the weekend, and they may even ask for a continuance to delay the hearing. And so once the petition is filed, it automatically buys them 5 days. It's an automatic 5 days. And so they know, even without proving their case, without presenting any evidence, all they're going to do is file this petition, which normally is a 2-3 page document at most that has very bare facts. In my experience, they don't even meet criteria under the Baker Act, but that's a whole other conversation. And they automatically get this time. So that's why I say, and I've said in other videos, time is of the essence with these cases. You need to move as fast as you possibly can and get and avoid going to the hearing. If you can avoid going to the hearing, there's an excellent chance your loved one will be out and won't have to spend an extra 4 or 5 days in the facility. So with that said, another great question. Thanks for tuning in. Feel free to call us. I never charge for a consult. Email me, message me through the website. And with that said, see you in the next video. Bye-bye.